Hello, everyone, and thank you for being patient with us as we work through these technical issues. I know we're going to take a lot of lessons learned from this COVID-19 era into the future. So I just want to introduce our moderator, Preston. He's a member of Miller and Chevalier. He leads the firm's complex civil litigation practice and is a member of its executive committee. He was an assistant U.S. attorney in Chicago, where he was the lead in a number of False Claim Act investigations, as well as other trials and appeals. Since then, he's been heavily involved in major internal investigations. He was second in Boeing's defense business, was the head of internal investigations and commercial lit at GE Healthcare, and has been appointed as a compliance monitor several times, including most recently as a deputy by the Massachusetts Gaming Commission in the recent Win Me Too scandal. Preston practice continues to focus on civil level internal investigation and related litigation. So with that, I'll turn it over to you, Preston.
Marquisa, thanks very much. And we are very much honored to have the opportunity to speak to NCMA-Huntsville. We've heard great things about this chapter, and obviously you are in a critical place. We have a number of friends in the area as well. By our count, we had well over 60 or 70 RSVPs, and I hope that as we continue to talk, more folks will come into the room. Looking at the number of folks who showed up, I think there's good reason, if I can humbly say so. The panel that is before you, my colleagues from my firm, are, if I can say it, really an amazing group of talented lawyers. And we're confident, as Marquisa said, that everyone will learn something valuable from their presentations and, of course, from this era. Just by way of introductions, if we can go to slide 4. A couple of just housekeeping things. Of course, although we are lawyers, we don't represent anyone on this call, and we're not providing legal advice through this webinar. So that's, of course, something to keep in mind. And also, let's go back 2 slides to the questions address. There we go. Thank you. So if you have any questions during this presentation, please send them to events@milchev.com. Again, for those of you who are on the phone, events@milchev.com. So we can go to slide 4. All right, so first we're going to start with Abigail Stokes, my colleague at the firm, counsel at the firm. Abby is counsel at Miller and Chevalier and represents government contractors in all types of litigation, including claims and disputes and bid protests, as well as counseling related to compliance concerns. She has extensive insight into the federal acquisition process through her experience as an acquisition attorney for the Navy Office of General Counsel, where she was for several years. While with the Navy, she advised on numerous complex acquisitions, successfully defended multiple GAO bid protests, and was critical in one of the Navy's first competitively awarded OTA consortiums. Welcome, Abby. Next, we have Erin Sweeney. For those of you looking at the slides, she's just right next to Abby. Erin advises on all facets of healthcare, including the Affordable Healthcare Act compliance, health privacy, HIPAA, welfare benefit claims, health insurance continuation, COBRA, U.S. Department of Labor audits and investigations, and employee benefit plan administration. She previously served as a senior benefit law specialist for the Office of Regulations and Interpretations at DOL, where she served as the primary architect of the department's qualified default investment regulation. She also served as an expert witness for the United States in multiple ERISA criminal matters. We'll go to the next. And just so we now have Jorge Castro, who also is a member of the firm, and he's a member of the tax department, where his practice focuses on tax policy and regulatory matters. He advises clients before Congress, the Treasury Department, and IRS. Jorge brings broad government experience to his practice, having served as counselor to the IRS Commissioner and as senior tax counsel in both the U.S. Senate and House of Representatives. I welcome the panel. Let's go to the next slide. Very briefly, what are we going to cover today? We're going to talk about COVID-19. We're not going to cover the stuff that is always in the headlines and the doom and gloom of it, but really, how do you do business in this environment? How do you survive going forward? We know that obviously as government contractors, as many of you are, or on the government side, everybody's got the same aim. We want to get through this time. So we're going to cover some key areas, government contracting being one of them, employee benefits, tax, and then we're also going to cover fraud risk, False Claims Act, and issues of that sort. We'll be with you until 12:30 today. However, you've now seen everyone's contact information, so please feel free to contact any one of us after this presentation because we are more than available to continue the discussion whenever you need to do so. And Marquisa, of course, has our contact information as well. We'll go to the next slide. All right, very quickly. To set the scene for a moment, we know that the circumstances we're dealing with, they're very familiar. We see them every day. They dominate the headlines. The pandemic, true to its nature, is global, right? So that's why once upon a time when we started these webinars, there were parts of this map that were not colored in. Everything's colored in now, right? Obviously, the pandemic has hit certain places harder than others. We know that as well. But we know that this is not just a blip on the screen. It's said to be a continuing thing that we're going to have to deal with. So our businesses are going to have to deal with it, and the government's going to have to deal with it. Go to the next slide. The questions we addressed today, obviously, is how does this impact you as a government contractor, and as an employer, and as a taxpayer? The statistics here are well known. I don't need to go through them, but you understand kind of the evolution of this, and obviously there's more phases to come. With that, let's dive right into the meat of our program. Abby, would you start us off?
Sure. Hi, everybody. Thanks so much for joining us. Next slide, please. So I'm going to highlight today some issues that our clients, our government contractor clients are generally encountering right now, and some legal issues associated with those challenges, and consider sort of best practices to make our way through this situation. Our end goal for our clients is to come out of this in compliance with their contracts, well positioned to recover any increased costs, and prepared for any audits or investigations down the road. So what's happening right now? In theory, business, we're conducting business as usual. Everybody's just working 100% remotely. We all know in reality that's not entirely true. We are all working remotely to the extent that we can, but there are a lot of disruptions in the government contracting process. So we're seeing labor impacts, we're seeing supply chain challenges, and travel disruptions. And many of these situations are resulting in increased costs to perform, changes to actual contract requirements, including manner and method of performance, and in some cases, or maybe a lot of cases, delays or even inability to perform. Some of those incurred unexpected costs are listed here. Telework equipment, so most contractors were not set up to facilitate 100% telework. So it took a lot of scrambling. I think we've worked through a lot of these issues, but still it's an ongoing challenge, and it's creating additional costs that were not anticipated. Increased costs related to IT resources. So the IT to support that 100% telework is not insignificant. Employers are spending additional money on employee health resources, so telework, telehealth services, workplace health safety resources. So for those businesses that are still open, they've had to incur additional costs for facility cleaning, sanitation supplies, costs related to idle labor and loss of efficiency or productivity for, like, many of us are trying to work our full-time jobs and also care for family members and kids whose schools are shut down. How to pay for leave, so paid sick leave or other types of paid time off. And then also finding and engaging alternative sources of supply. The supply chain has been impacted in a lot of ways. Some of these costs, it's important just to highlight that some of these costs may be company initiated, so adjustments that companies are taking to adjust to the situation, or in some cases by government direction. That's important just to recognize and keep an eye on, because it may impact your ability to recover those costs later. Next slide. So the government has been issuing a ton of guidance and various forms of relief, and I'm sure everyone is incredibly confused or following it all to the T. There's a lot out there, so I didn't list it all here for fear that we would have too busy of a slide, but I did highlight for you some of the more important guidance documents that have come out and legislation that we've been talking a lot about and could have actual impacts on you. So first, here is the OMB memo 5/2018. This was issued on March 20th, 2020. This is not guidance for contractors, it's guidance for agencies, but it's particularly interesting in that it tells you sort of the perspective that the government is coming from and the guidance that the agencies that you're working with are receiving from higher up. So this memo, I encourage you all to actually take a look, because it really is helpful. This memo affirmatively tells agencies to consider telework options for contractors and consider modifying contracts to allow it. We've seen since this memo came out, some agencies have actually taken the initiative to issue entire class deviations that apply to all of their contracts that allow for the 100% telework or nearly 100% telework. So this type of guidance it's being followed closely by agencies. The memo also encourages granting schedule extensions. So if performance is impacted because of COVID-19, it encourages agencies to grant schedule extensions, no-cost schedule extensions. It suggests that if a contractor cannot perform, the agencies should consider an array of options that include no-cost terminations for convenience, stop work orders, so a pause for 90 days, a number of options that encourage agencies essentially to consider any option other than defaulting a contractor. It also advises agencies against issuing negative CPARs related to performance impacted by COVID-19, which is incredibly important because those, of course, as we all know, can impact your ability to get contracts later. It also encourages agencies to consider approving REAs to cover those increased costs that we talked about and provide the schedule relief. So this really sets the tone from the top for agencies. The message is very clear: support the industrial base if at all possible. Hopefully everyone is receiving that same message from your agencies. But like I said, this is a good one to go take a closer look at. Second, this is legislation, the CARES Act, the Coronavirus Aid, Relief, and Economy Security Act, that was signed into law March 27, 2020. So this is an over $2 trillion economic relief package that everyone's talking about, so we've all probably heard about it, but it's important to pay some attention to Section 3610. So 3610 applies to federal contractors, and it allows, in plain English, this is not going to capture the complexity of the statute, but in plain English, it essentially authorizes agencies to reimburse contractors for incurred leave costs to keep employees in a ready state if they cannot work due to COVID-19. So that's overly simplifying the requirements of the statute, but that's essentially what it allows agencies to do. And important to note that it allows agencies to do. This is not a mandatory requirement. Nobody is required to get reimbursed for this type of leave, but it gives agencies the option to reimburse this type of leave. So if you're in a situation where you do have employees that cannot work due to the COVID situation, this is certainly something that you should go and look at the conditions and see if you fall within those categories and start having a conversation with your contracting officers about it. So in particular, the statute, some of the conditions are that the employee, first of all, the employee needs to be in a ready state. So you're going to have to justify in writing and not just state my employee needs to be in a ready state. You're going to have to explain why your employee needs to be in a ready state. What would happen to the mission if you didn't keep them on the payroll? Why the employee cannot physically perform at the federal worksite. So the statute requires that the employee cannot physically perform at the federally approved worksite due to site closures or other restrictions. So it's somewhat broad. It doesn't necessarily mean everything is shut down. There are other ways that you can meet this condition, but you need to think that through and you need to document it in writing. You need to document why the employee cannot telework and what you've done to continue performance and why it's not feasible. Note that this applies to the FAR and non-FAR contracts, so the statutory language specifically applies to contracts and other agreements. So this would apply to alternative acquisition agreements such as OTAs. It only allows for it allows for reimbursement up to the minimum applicable contract billing rate. You're going to have to put some thought into what that means. Because it really depends on the type of contract, and that particular term is not terribly helpful. But if you do, depending on the agency that you're working with, many of these agencies have also issued implementing guidance, and some of them give a little bit more insight into what that particular term means. And it's also reimbursements only allowed up to not to exceed an average of 40 hours per week. This allowance goes through September 30, 2020, yet to be determined if that will be extended, but it takes us through the end of the fiscal year at least. Also importantly, the very last sentence of this statute has a tucked in there sentence that is rather important, and what it amounts to is no double dipping. So any requested reimbursement must be reduced by essentially other COVID-related relief that the contractor is seeking or might get credit for. Specifically, it references the Families First Coronavirus Response Act. Next, I just have on here listed the OMB memo M 2022 that was issued April 17th. If you're looking to get reimbursed under the CARES Act, the first thing I would do would look at that statute and then look at this OMB memo, which provides pretty detailed guidance guidance for agencies implementing the CARES Act. Then, of course, you want to. There are a number of agencies, like I said, that have implemented this particular legislation, and their guidance is going to be critical for seeking reimbursement from your agency. If you haven't seen guidance from your particular agency, I would suggest looking at the DoD guidance because it's very robust and detailed and can give you some insight, at least on how DoD is interpreting it. So DoD has implemented this particular statute and relief function via DFARS 231.205-79. This is essentially a new cost principle that allows for these types of leave costs and outlines the specific conditions. DoD, along with this deviation, has been issuing an evolving set of FAQs that are also very helpful. They are on, I think, FAQ number 31, and they provide pretty detailed answers. At least they're not all incredibly satisfying, but some of them can give you some insight into things you need to be thinking about, or at least what the answer is going to be from the government with respect to your questions, like how do I charge this, indirect or direct? And I've included this particular website on here because this particular website is quite helpful. They're listing a lot of COVID resources on that DPC website. Next slide, please. So next steps, what do you do? You all are probably dealing with some of these issues, or you may be at some point if you're not yet. So what do you need to do? If you haven't done so already, the first thing to do is, it sounds basic, but we often forget, go back and look at your contract. Our FAR contracts are fairly similar across the board, and we think we're very familiar with what clauses should be in there, but you got to go look and see what's actually in there. So understand the terms and conditions in your particular contract, including look at your SAL and look at those H clauses, because sometimes there are sort of hidden clauses in in section H that you might forget about. The SAL in particular is important, especially if your manner of performance is changing. You need to make sure you're still it feels like the Wild West, but it's not the Wild West. All the regular contracting rules still apply, and you're still obligated to comply with your contract terms. So if you're being asked to perform in some different way or meet a different requirement, you need to make sure that that's in compliance with your contract. And if it's not, you need to talk with your contracting officer and get your contract modified to ensure that you're in compliance with your contract. We've listed for you here some of the more important clauses that you should be looking for specifically. See what changes clauses are in your contract. Look at your excusable delay provisions. Importantly, if you're facing any of these issues, go back and read these clauses, the clauses that apply to you, and try to make sure that you are identifying what proactive steps you need to take now. Many of these, to obtain relief, in many situations, there are things you need to do in a certain time period. For example, provide a certain type of notice, and you need to make sure that you do that so you preserve your right to recover the costs or get the relief you're seeking. Importantly, I don't have this on here, but this look at your contract is even more important if we are talking about OTAs. OTAs, as most people probably know, are non-FAR instruments, and the FAR doesn't apply. So while you may see FAR clauses in there, you probably shouldn't see FAR clauses in there. And what that means is the terms and conditions from one OTA to the other are going to be very different. And if you do find yourself in a dispute, those terms are going to matter a lot, and it's going to be much more like a commercial dispute than a normal government contracts dispute. Next slide. So again, sort of realistically, logistically, what do we do now? The first and foremost, engage your customers. Start that line of communication. If you have a good relationship with your contracting officer, your core, now's the time to leverage it. Make sure that you are talking about whatever issues are coming up and you're on the same page. Consider whether you need to, and if you don't have a good relationship with your contracting officer or your core, now's the time to make sure you establish that, because you need that line of communication right now. Consider the need to alert customers of increased costs. Consider whether you need to request waivers from compliance obligations. So do you need to substitute out key personnel? Do you need relief from some sourcing restrictions? Like I said, if your manner of performance is different based on the situation, do you need some update to your SAL? Provide early notice of potential performance issues. I should have underlined here, also make sure that if you are providing early notice of potential performance issues, you also provide your assurance of continued performance. What you don't want is that early notice to be misinterpreted as an anticipatory repudiation. If you get any U.S. government instructions, so for example, changes, orders, approvals for anything. So if you're changing your manner of performance and the government approves that, if you receive stop work orders, terminations, follow the government instructions to the T. And then what we've probably all said 100 million times, but now more than ever, it's really important. Document, document, document. So all communications and actions and costs, it's really important to document these things so that when and if you need to come back and recover those costs in the future, it's very clear what happened, who approved it, and what exactly they approved. This is particularly important under the CARES Act 3610. That documentation to seek reimbursement and any backward-looking audit or investigation into getting those funds, it's going to require a clear explanation of what those conditions were, and that your contracting officer understood how you were interpreting the conditions, and that you both were on the same page and it was approved. So you worry, in that situation, we worry a lot about when you're questioned later, if the contracting officer is not there anymore, you can't remember exactly what the explanation was, and the record is not clear enough to show how exactly you met those conditions and that it was approved by your contracting officer. And then finally, track and segregate your costs. So it's really important. I think folks are already doing this, but if you're not, you should be separating your charge codes to support your future cost recovery efforts. So all of your COVID-19 related costs, you should be separating those out. And as you think about how to separate these charge categories, make sure that your categories are in compliance with your contract terms, FAR cost principles, and your CAS disclosure statement. And finally, when in doubt, seek guidance. Some of the best guidance should be right from your customer, because out of their mouth, that's the guidance that you need, and that's the instruction that you need. Also, consider seeking guidance from your advisors. You know, this is the type of situation that results in a lot of disputes later. So contract disputes, like we said, audits, investigations later, and now is the time to set the stage and really avoid those later disputes. And that's it. Next slide.
Okay, thank you, Abby. We're going to now move into a discussion of how you as a government contractor can respond to the rapidly changing employee health needs of your workforce. And, you know, we in this team have been doing these slideshows on COVID-19, you know, for since March. And you know, the spin now is, you know, quite a different one. Where we started out, the question was, you know, can you have enough hand sanitizer? What can you do for cleaning? Then we moved into a telework phase, and now we're moving into really the next big era of the COVID-19 response is, how do we reopen America for business? And you know, and as we know, some states have opened up different components of their operations, and we should anticipate that there will be some opening in different locations and potentially where your employees are located. And so, it's important to recognize, you know, what does this mean, and how is this going to happen? And I think the other issue is that you know, as we can all see from the news, the states are implementing their directives very much individually, and so it's important, especially if you have multi-state operations, to understand exactly what directives are in place, what kind of movement can occur, and what businesses can operate. And you know, some states have a very detailed list of what is opening and what is closing, but it's important to be very focused on the individual state directives. And you know, with respect to reopening America for business, one of the key questions is, how are we going to determine whether or not you know, people are safe to go back to work? I mean, putting aside what happens if ultimately the governors decide that you know, either you know, the hospital admissions or the ICU beds are full and we have to like scale back. But you know, it's going to be a very structured and measured reopening in most places, and there is likely to be guidance from the governors. Like what we've seen is that different governors have different views of what's the appropriate percentage. You know, one of the issues is, well, how much capacity do hospitals need to have before we can let people go back to work? And go back to work isn't going to be the same way that it used to be. It's going to be back to work with social distancing, with masks, with daily cleaning. And the question, you know, the question there is, you know, what do those numbers look like? I mean, we've seen that, and we'll talk more about elective medical, and when, you know, the whole, you know, when we're going to stop treating hospitals as emergency ICU only and move it back to a place where people can receive care. But let's talk about the testing. I mean, testing has been in the news a lot, and you know, the question is, you know, can your employees get testing if they need it? And the answer is still probably not. The testing facility in this country is heavily dependent, for the diagnosis testing, is heavily dependent on components. And, you know, as government contractors, we all understand that piece of it, that it's not that the tests aren't available, it's that the swabs, the reagents are not available. And so we have the president who has utilized some of the tools at his disposal to, you know, to try to free up resources under, you know, under his ability to actually, you know, as we know, he's going to be able to prioritize some of these different pieces, the reagents, the swabs. But the question really is, you know, who's going to pay for the testing? I mean, and, you know, who's going to pay for the testing, and what does it do for us? Like, is it going to actually help us open? And is this helpful for employers? And what we did get from our regulators is we got guidance that made it clear that under the CARES Act, that testing for the detection of or the diagnosis of COVID-19, that's going to be covered at first dollar. And so what that means is that, you know, your employees aren't going to have to pay for it. You know, the real concern and the issue that that states and medical service providers have been grappling with last week and this week is, what about the antibody testing? And antibody testing is the idea that you can take a blood test, a quick, you know, a quick finger prick, and the test should ideally tell you whether or not you have antibodies to COVID-19. And in theory, that's a great theory. However, what we've heard from WHO, of course, is that there is no evidence that COVID-19 individuals who've had and recovered from COVID-19 have antibodies. Well, what we do know from a biological point of view is typically that you do have antibodies. Like, you know, in general, in biology, humans do develop typically an antibody to a virus, and we expect that this would perform in the same fashion. However, we don't know that it does, and there's been no testing on this front. So that's, I think, where the WHO has tried to make it clear that you can't really give people, you know, sort of a get out of jail free card, like you've had COVID-19 and you can go back to work. The antibody testing also is, you know, the question of whether or not the antibody testing is going to be required by employers. Can employers require it? Who administers it? Who pays for it? And these are the questions that, you know, I've been working with a lot of health insurance carriers, and they've been working with their departments of insurance to try to come up with, you know, who is going to pay for this, and what does this look like? And this is important, especially if your business operations are going to depend on some level of testing. And as I mentioned before, the CARES Act indicates that testing for the detection of or the diagnosis of COVID-19 is covered at first dollar. But that is about whether or not an individual, like a clinician, decides whether or not that person has the virus. And so the question of whether or not, you know, employers can require diagnosis testing, it's, you know, that type of level of testing really would be done by a clinician. So the next front that everyone has moved to is, well, what about antibody testing? I mean, can employers set up a clinic, let's say, at their place of work and have everybody go through antibody testing? And the word on that is really not so fast, because I know that a number of departments of insurance are weighing in here, and the Department of Labor issued some, and HHS issued some guidance on April 11th that was intended to provide some help on this front. And what they said in the FAQs that were issued, and as we know, our regulators, Department of Labor, HHS, and IRS are issuing quite a few of what we call sub-regulatory guidance. So guidance that's not in the traditional form of regulations, but in fact is FAQs. And under those FAQs, the Department of Labor made it clear that antibody testing is within the definition of the tests that are covered at first dollar. But what they say, though, is that the FDA says that that test should not be used as the sole basis for diagnosis. And so the question that the departments of insurance and employers and interested parties are dealing with is then, well, okay, if it's not for the detection of or the diagnosis of COVID-19, what are the parameters? So is there this medical necessity component to obtain an antibody test? And so the argument is that at least some of the insurance carriers are taking the position that yes, there is a medical necessity component to receiving an antibody test. And so the question is, when would that be medically necessary? And some of the concerns that I've heard raised are, well, what about surgery? Like if a person needs to have surgery, then is it medically necessary that they have the antibody test? Because maybe they need both the diagnosis test and the antibody test to determine whether or not the person might be infectious, but also whether or not they've had it. And one of the things that we've seen in COVID-19 is there's a very significant clotting issue with COVID-19, so that like the concern would be if you're having a surgery or dialysis and the person is having clotting issues, you would want to know that. But that leads to the next question of, okay, there's a scale here. Okay, what happens now that we have some states opening up for elective surgery? Then is the antibody testing, is that covered at first dollar then? What about dental procedures? Dentists want to reopen. And then sort of next down the line is employers. Can these tests be paid for by the health plans? And again, that's a very topical issue at this moment. I would say that it's more to come on that front. But one of the things that a lot of carriers have pointed out is that in the most recent package of relief that we've received from the government, there's $11 billion that's slated for employers to conduct testing. And so the implication is that's employers that conduct that testing. Concerns also, of course, are that antibody testing is far from accurate. And on the best day, we're seeing a 15 to 20% swing, false positive, false negative. And so what that could give somebody is false comfort that they're actually able to get back in the workplace. They could say, well, I've had it, but it turns out they don't. So, again, and then there's also the issues of liability waivers, which we're hearing a lot in the news. Like, are employers going to get some kind of blanket liability waiver so that they can bring people back to work? And if there's a COVID-19 outbreak because we don't have the ability to test, or there's no way to manage these parameters, then it is something going to come along those lines, and employers are asking for and lobbying pretty intensely on that front. I do want to point out that we just got some guidance this week on employee benefit plan extensions, and what this means is that we had a public health emergency declaration on January 31st, 2020, and we received some pretty quick guidance from HHS indicating that if you're going to modify your employee benefit plans to allow for treatment at first dollar for COVID-19, or to allow for this testing, that you would typically have to provide those notices to your employees 60 days in advance of those changes. But we learned on April 11th that the standard was going to be that this would have to be provided as soon as practicable. And so that was the guidance that we had on April 11th. But just this week, we got even more help from HHS and Department of Labor. What we now know is a whole variety of deadlines associated with your employee benefit plans have now been essentially paused. And so from March 1st, 2020 till 60 days after the end of the emergency, all of those special enrollment periods for health are paused. Notifications required by your employees that they've had a qualifying event paused. Any COBRA notices that would need to be issued, the 60-day election period for COBRA, the 45 days to pay, all paused. Also the claims procedure, so if individuals have to file a benefit claim or an appeal or an external review, all of these have been paused. All of the notices that employers have to provide, required notices or disclosures under the plan, also paused. You can provide these as soon as practicable. very helpfully, there is some statements that you could reach out to your employees in any way that makes sense. You don't have to use the standard procedures. You can make something accessible on your website. You can text them. You can use a lot of different components. There's also really a sort of a general good faith standard. The HHS and DOL have indicated that they are going to be in an assistance phase as opposed to an enforcement phase. So all of these things are very good. They provide some release of some of the stress in the machine, if you will. There are also some additional provisions related to plan loans, distributions, even getting participant contributions into your 401k plan, loan repayments, blackout notices, filing 5500s for the plans themselves, and M1 filings. So all of these standards, you can think of them as being paused until the end of this crisis, and everyone is supposed to do the best they can. It does raise a lot of questions about sort of an ongoing, never-ending, COBRA election period, but again, what the Department of Labor wanted to do is to make sure that people had the ability to access their benefits. So if we go to the next slide, please. Okay, and here I just wanted to touch briefly. We've talked a little bit about telehealth. Just wanted to mention that we've seen again some assistance from our regulators on providing telehealth to those participants who have the high deductible health plans, where they usually have a pretty significant deductible, but the Department of Labor and Internal Revenue Service have they've waived that high deductible so that telehealth can be provided first dollar. We've also seen HIPAA waivers from HHS, also making it clear that even if there wasn't a business associate agreement in place for these kind of telehealth providers, that as long as everyone works hard to get those HIPAA guidance and business associate agreements in place, that is going to be satisfactory. We've seen a number of employers think about second open enrollments. Are they going to allow an additional open enrollment? We've also seen that the states have opened up their exchange enrollment periods. 11 states have done so. We've also seen employers who have decided to coordinate their unpaid FMLA leave and COBRA to provide additional benefits. And we're starting to see signs from our regulators that these types of actions are going to be supported. And I think the second open enrollment, the one issue to pay attention to though is the pre-tax dollar component of your cafeteria plan. And so we're seeing people work through those issues as well. And if you could move to the last slide. I did want to just spend the last few minutes that I have talking about some of the reimbursement and hospital issues that have been raised and what we might see here. And really the questions here are whether or not these type of benefits are offered under your employee benefit plan, and if these are out of the box and what will be covered by your medical service provider, as well as what your insurance carrier will be paying for your employees. And top of the list last week and this week is remdesivir, which is the one treatment that we have that is effective on COVID-19. We don't have a cure, but what we have learned is that this is the only treatment that we have thus far that can lessen the amount of time that people are in ICU. And so this is obviously an important achievement. We do know that there are many, 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 many different trials that are undergoing with respect to other medicines that hopefully will also be able to reach a trial stage where we can have conclusions about their efficacy. And the question here is the medical service provider and is going to administer this medication, and whether or not the carrier is going to pay for it, because it's going fast track FDA approval, but right now there isn't an approved use of this medicine. Also just want to point out that there's a lot of novel treatment going on right now. Radiation treatment, which used to be done as a historical matter when people had pneumonia before we discovered antibiotics, people's chests were x-rayed to slow the progression of pneumonia. We're going back to this now because we don't have a cure for COVID-19. People's chests are being x-rayed to try to slow down COVID-19 in the same way that we used to many years ago. So these novel treatments and who's going to cover them. What we do know is, we've certainly heard from Medicare and Medicaid on quarantine coverage, and we've heard that if individuals have to stay in the hospital, even though they technically don't qualify anymore for a hospital stay because they don't need acute care, they're permitted to stay in the hospital for quarantine reasons. We're starting to see less of sharing of ventilators, which there was a movement at least a month ago before we all went to shelter and safer at home of sharing ventilators and whether or not that was going to be covered. We're actually seeing a pullback as the cases have gone down. But again, as we're talking about reopening America, we could be back to some of these places. We're also seeing as an effective treatment, plasma transfer, which is used in a lot of different diseases, but taking the plasma from recovered survivors of COVID-19 and then providing that to people who have COVID-19. And what's the coverage and who's going to pay for that. And then surge care, which is the provision of medical assistance at facilities, convention centers, places outside of the hospital. And we're seeing, at least in New York, they're starting to scale that back, but other places are still turning into hotspots and are still readying their beds. So, just wanted to identify, these are some of the issues that are being addressed and what to do to reopen the workplace. And, again, everything is quick moving and still in motion. But with that, I'm going to turn it over to Jorge.
Great. Thank you very much, Erin. So I'm going to talk about the tax issues that we're currently confronting. If you can please put the next slide. I'll give you an overview, and then we're going to jump right into kind of the tax provisions with broadest applicability to government contractors and employers. So just to kind of start with the background, we've had 4 major bills that Congress has passed in lightning speed in the last 6 weeks. Back in mid-March, early March, HR 6074 was passed, which was primarily appropriations for a number of agencies to start combating the coronavirus. The second phase of the bill, the second phase bill was HR 6201, passed in middle of March, which the only tax component was a payroll tax credit for paid sick and paid family and medical leave. There was a similar credit that was enacted in this bill for the self-employed as well. And then phase 3 is the CARES Act, which my colleagues have spoken about already, which was which has been the most significant and most encompassing bill that Congress has considered and passed. The bill, as Abby mentioned, was over $2 trillion, unprecedented. It moved in lightning speed through House and Senate. So as you can imagine, that led to a number of issues that have to be clarified and have to be corrected in the legislation. So those are issues that are likely going to be considered going forward. Also, in this bill, the major non-tax components, as you've seen in the news, have been read about. Expansion for small business loans, extension of unemployment insurance, the recovery rebate checks that the IRS is currently processing, a number of healthcare provisions, and additional appropriations. And then to the next slide, the most recent bill that Congress passed is HR 266, what's considered phase 4, or also considered CARES Act 2.0. There were no tax provisions in this bill. It was, while it was very large bill, it was very discreet. Primarily was additional small business loans to the Paycheck Protection Program, the SBA loan program that is very prominent. It increased funding authority for the loan program by $321 billion, and also additional funding for healthcare providers and hospitals, and also for COVID-19 testing. If we can move to the next slide, please. So I'm going to cover this presentation is not intended to cover every single tax provision that's been passed by Congress recently, but we wanted to cover the two provisions that have the broadest applicability to government contractors and employers. And the first is the Employee Retention Tax Credit, which is a new tax credit that Congress passed in the CARES Act. As you see in the slide, it's a refundable payroll tax credit for 50% of wages to paid to employees during the COVID-19 crisis. And it's a two-step process and equation. The first is determining what's the eligible, what are the eligible employee wages. And that's has a two-part question. First is for employers with more than 100 full-time equivalent employees, only wages paid to employees who are not providing services, i.e. they're not working because they're furloughed or face reduced hours. Those are the wages that are eligible for the credit. Now that's different. Compare that to the for employers with less than 100 employees, where the credit applies to wages paid to all employees, regardless if they worked or not. If the employees if the employees worked full-time and were paid for full-time work, the employer still gets the credit. So significant difference there for employers with more or less than 100 employees. And then the second part of the equation is how do you determine the universe of eligible employers? And the credit's available to two types of employers, including nonprofit tax-exempt entities. First are those employers whose operations are fully or partially suspended due to a government order related to COVID-19. And the second group are employers that have experienced a greater than 50% reduction in gross receipts compared to the same quarter in the past year. A couple things just to highlight here. A government order is broadly defined as an order by federal, state, or local authorities. So that's important to note. There are still remain to be open questions about what happens to those employers who suspended or closed their operations or partially suspended their operations absent a government order. So they proactively took those steps. Those are questions the IRS is still continue to address, and we'll see. I think that's why it's important to keep track of the current IRS guidance, which I'll mention in 1 second. The most recent guidance that was issued. The credit is provided for the first 10,000 in wages, including healthcare expenses paid to an eligible employee. Also, the credit applies to wages paid after March 12, 2020, and before December 31st, 2020. A couple of things to note. Employers that receive loans under the SBA Paycheck Protection Program, the PPP loan program within the CARES Act, are not eligible for the retention credit. Something to keep in mind. So it's going to be important to kind of weigh both of the value of both provisions to businesses. Also, I want to leave you with the most recent guidance by the IRS, IR 2020-62, which was just updated last night. And as my colleague Erin noted, was by way of FAQs, which has been the most common way that the IRS has been transmitting guidance and how they are interpreting the the new legislation passed by Congress. The FAQs, which were updated last night, include over 100 questions, which are pretty broad and kind of will answer a lot of your questions. So I want to leave you with that in mind. Also, there's information about how employers can receive the credits and get reimbursed. So I refer you to Form 7200, which outlines how to get an advance payment for this credit. Can you go to the next slide, please? The second most common tax provision within the CARES Act is the delay of the employer payroll taxes. And this one is a little more straightforward. This is a provision that allows employers to defer payment of the employer's share of the Social Security payroll tax. So that's a 62% portion, up to $137,700 wage base. The 2020 deferred payroll tax is allowed to be paid over the next 2 years, which half of the amount due by December 31st, 2021, and the other half due December 31st, 2022. So it's a significant delay of the payroll tax that would otherwise be due this year. And this applies to payroll taxes that would have been due, that are due from the date of enactment of the legislation through the end of the year. Two things to note: IRS also has issued FAQs on its website, which I refer you to, which are very helpful. And also, the other thing to note is that just like the retention credit, there are restrictions for those employers that receive loans under the Paycheck Protection Program, and those that want to take advantage of this payroll tax deferral as well. So something just to keep in mind as well. If you can go to the next slide, please. So next is I want to give you a preview of what to expect next. So Congress is currently out of session, although they're still working. Obviously, staff is still working and members are still working. And the expectation right now is that there's going to be additional COVID-19 relief legislation in the near term, when we consider it to be phase 5. And let me just outline a few of the items that we think are going to be considered by both the House and Senate and the White House. I'll start by kind of talking a little bit about the employee retention credit, which we just covered. I expect there to be considered an expansion of the credit. Particularly, there's a discussion about expanding the credit for those employers that have retained employees during this pandemic. That's something to consider. Also, there's going to be additional discussion about how to have additional tax relief and funding for small businesses, particularly when you talk about impacted sectors that have been impacted in a disproportionate fashion. We often hear about the food and beverage and restaurant sector as well, as being part of that list. Also on the discussion will be expanded paid family and sick leave, additional funding for state and local governments, infrastructure investment, which is a big project for the White House, additional payroll tax cuts. The president came out with comments about that in the last 24 hours. So consider that to be on the table. There's sometimes, there's additional economic relief for families, including additional rebate checks and also food assistance, particularly under the SNAP program as well. Those are issues that are going to be on the table. Next slide, please. If I can just kind of summarize real quick. So without a doubt, the coronavirus crisis is having a major impact on the current tax legislative landscape. Had you have asked me 7 weeks ago the number of tax bills that Congress was going to pass this year, I could count them probably with one finger. But that's significantly a change. So expect additional legislation. With that, it's very important to follow the current Treasury and IRS guidance process, which is going to give more color and context and details to a lot of these provisions that Congress is passing. Also, I think depending on the severity and the duration of this pandemic, I would consider, in addition to what could be considered phase 5, additional tax legislation that could be considered this summer and fall. This is obviously a very fast-moving process, so it's very important to be engaged and to evaluate the pros and cons and burdens of a lot of these proposals. Congress is working, and they are considering feedback in a lot of these provisions, so keep that in mind. As I mentioned, in addition to what Congress is going to pass, in terms of additional bills sometime this summer and fall, I consider that we consider this to be, for it to be also a very active lame duck session in Congress post-elections as well. And also lastly, for us tax policy specialists who follow this very closely, clearly the pandemic is having an impact on the priorities of the presidential candidates. So keep that in mind as policy priorities are outlined, which will have an impact clearly in the 2021 agenda, which is just around the corner, and that could be additional tax relief measures as well. So with that, I'll pass it on to Preston.
Thank you, Jorge. If we can go to the next slide, please. Okay. So just to kind of recap what you've heard so far, our firm, which is in Washington, D.C., is staying very close to all of these issues. Again, government contracting, employee benefits, and tax policy. We can answer questions that you have along those lines. There's one more piece that we should cover that is not so native to just DC, but certainly is a big part of the discussion in DC now, which is enforcement. And it is in times like this, when you're dealing with a pandemic, a crisis, something that takes a lot of resources to get over, and frankly, folks are not quite sure what the path forward is, fraudsters and companies that don't necessarily pay attention to how to do business the right way, nonetheless avail themselves of government funds. Why is it important to pay attention to enforcement? Because obviously those who are on this call, we have the mind of, we want to do the right thing. There's more than 2 trillion reasons on the street right now as to why we need to pay attention to enforcement. Obviously, when I say that, I'm speaking to the private side of this chapter's membership, those who are contractors. But these things are very relevant to contracting officers as well, making sure that, again, T's are dotted or T's are crossed and I's are dotted. First of all, remember that the CARES Act itself, as I understand it, is more than 850 pages. I will not attest to have read the 850 pages myself, but there's a lot in it. And what that means is every enforcement agency that guards against fraud is rightfully on high alert. We list some of those agencies here on this slide: the SEC, CFTC, IRS, and GAO, DOJ among them. One of the principal areas of risk that are native to a time like this is the False Claims Act. And while this is not meant to be a tutorial on every part of the False Claims Act, recall that it applies to any person or company that submits a false claim for payment on the federal government, or causes a false claim for payment, causes someone to submit a false claim on the federal government. For example, a subcontractor giving false data to a prime that then submits that on to the federal government. And there's a variety of ways I'm sure all of you are familiar with in which one can run afoul of the False Claims Act. For example, one of the things we talked about in this presentation was the fact that if you take advantage of the CARES section 3610, we're not to double dip, right? Similarly, what are the rates that should be charged for that labor, and what reimbursement rates are you seeking, right? There's a lot of other ways. So if those you provide health care, PPE, are you providing it in accordance with the contract that you have with the government, or are you cutting corners? You're allowing your employees to cut corners. The False Claims Act means that I'm sorry. So another way that the False Claims Act becomes relevant, of course, is if let's say you request reimbursement under CARES 3610, but then you realize that your employees are actually able to telework. Well, retaining that money, not giving that money back, can be what's called a reverse false claim. And again, there's a lot of permeations of it. Now, it was actually in a time like this when the False Claims Act was first created here in the US. It was during the Civil War when horses were being provided to the government that frankly were called decrepit horses, and they didn't do the job, right? And the contractors who sold those horses to the government knew they wouldn't do the job. Again, it's in a time like this when unfortunately certain folks come forward who should not be participating in the government procurement market. Our companies are losing money right now, a lot of them. You look at the economy is obviously very difficult as well. Our coworkers are losing jobs. We're stressed, we're tired, and we're doing everything we can to survive. At the same time, we've got to make sure that we're doing business the right way. And if we need help to know exactly what T's we should cross and what I's we should dot, then you need to reach out for help. Unfortunately, this is a time where employees, because of the stress, may have temptation to cut corners. Those of us who were practicing in the enforcement field, as I was back during the so-called Great Recession, we remember that what enforcement actions took place then, and you heard story after story, and you're starting to hear stories now, frankly. We know that the Special Inspector General that investigated, for example, the TARP bailout for the recession that was now more than 10 years ago is still working now, right? We know that Special Inspector General, per their own report from the last quarter, has recovered in investigations $11 billion, resulting in 381 convictions, which is a 96% conviction rate. Okay. Now, you take the temptation side of this and you couple it with that it's in times like this where employees and other stakeholders, businesses, for example, or even civic groups that want to make sure fraud is not in our system, are motivated to blow the whistle and look for potential fraud. Consider those, for example, who have lost their job and aren't quite sure how to move forward, but yet they see that their employers are doing well. They may look for reasons to blow the whistle, and rightfully so. The whistleblower bar has made it clear, like the lawyers who represent whistleblowers have made it clear, that this is a time that they're really on high alert. The National Whistleblower Center, for example, which is a collection of False Claims Act relator attorneys, or whistleblower attorneys, have sent numerous letters to the Department of Justice that really target the department's efforts to root out fraud, and they're pushing the Attorney General and the department to do all that they can to make sure that not only do they root out fraud, but that it's easier for whistleblowers to bring cases because of what's going on now, right? The FOIA process, for example, is streamlined, things of that sort. And if we needed another reminder from the government contract side, just a few weeks ago, the Comptroller General of GAO made the enforcement priorities clear in a very public statement, said that the public can play a critical role in helping to identify improper activities or weaknesses in programs that warrant scrutiny. And fraud.net, and those of you who haven't ever seen fraud.net, go to Google, type it in, you'll have a better understanding. Fraud.net can play an important role in alerting GAO potentially early on to questionable uses of CARES Act funds. The act has set aside over $2 trillion to address the public health emergency and related economic impacts. Experience tells us that the risk of fraud and abuse grows when large sums are spent quickly, eligibility requirements are being established or changed, and new programs are being created. Can we go to the next slide? So with that, we know that the Department of Justice, I was at one point an assistant U.S. attorney and was part of the Department of Justice. We know that the department is prioritizing the investigation and the prosecution of fraud, cybercrime, and other issues. The Attorney General has said that several weeks ago now, that the pandemic is dangerous enough without wrongdoers seeking to profit from public panic, and this sort of conduct cannot be tolerated. So as a result, all U.S. attorneys, meaning in every district, meaning in your district, for example, are to prioritize the investigation and prosecution of wrongdoers seeking to profit from the pandemic. That's a directive from the Attorney General. And there's other steps they're supposed to take. For example, each U.S. attorney is supposed to have a coronavirus fraud coordinator on matters that relate to COVID-19, to direct the prosecution of crimes related to the pandemic and conduct outreach and awareness. And in Texas, at the end of March, we had one of the first actions. We've had several since then, filed by the Department of Justice's Civil Division to address fraud related to COVID-19. And one of the other big things, we talked about the Special Inspector General that worked on the TARP bailout. Well, of course, the CARES Act has its own Special Inspector General as well, called the SIGPAR, or Special Inspector General for Pandemic Recovery, which will be headed by a presidentially appointed, Senate confirmed Inspector General. It's going to start with a $25 million budget and a 5-year mandate to conduct, supervise, and coordinate audits and investigations related to the loans that are being given out, purchases that are being made, and so forth. $25 million is probably just where they start, right? The resources will be greater. I think the public outcry will be loud for that office to be as empowered as it can be. So those are some of the issues from the Department of Justice side. You know, in healthcare, when you think about HHS, you know, think about issues like upcoding. The Attorney General has said that we need to be on guard for providers that are obtaining patient information for COVID-19 testing, and then using that information to fraudulently bill for other tests and procedures. So just as if you're in the healthcare field, you've already been close to your compliance duties. Do not cut the spend there, and make sure to continue to pay attention in that area, because even though today it may look like, well, you just have to cut a corner and you can't help it, the reality is, and this happens after every crisis that this country has faced, that whistleblowers and enforcement will come later, and say, look at what you were doing during this time. And unfortunately, you won't have the context that we have now that shows that maybe that you could try to use to explain why you considered cutting corners. Instead, your actions will be looked at in a vacuum for many years to come. And again, we said that the Special Inspector General for TARP is still working. So we're talking with the False Claims Act, a statute of limitations that can go as long as up to 10 years, believe it or not. For those of you who may be publicly traded, the SEC has been very clear about making sure that insider trading is being looked for, and that means that if you are publicly traded, that you need to be careful about your blackout dates. You have to adhere to them. Inevitably, insiders at your corporations will have information about your performance before that performance is made public, and you don't want them, of course, to trade on it. And there's numerous other ways that the False Claims Act can come into play. Frankly, there's numerous other statutes that are being examined during this time as well. The moral of the story is stay close to your compliance obligations, A, because it's the right thing to do, and B, because if you don't, it may be hard to defend later on. With that, we're now at 12:30, and I'd like to turn it over to Markeisha.
So thank you to the entire Miller and Chevalier Council for speaking to our chapter today and partnering with us. To all our NCMA chapter members and friends of the chapter, we will send out a certificate for your CLPs within the coming weeks. And again, I just want to thank you all for taking this time to attend and present. I think this will be recorded, is that correct? That it has been recorded?
That is correct, yes.
So we will share that with the folks who may not have been able to log on. So stay well, everyone. I'm in my home office, as you can see, but I hope to be seeing your familiar faces soon. Take care.
Thank you, Markeisha. Have a good day.
Hi, guys. Do you think we'll get a copy of the slides?
Yes.
We'll send you a copy of the slides as well as the recording.
Oh, that's wonderful. Thank you very much. It was an excellent performance. Thank you, guys.
Thank you. Have a good day.
Thank you. Have a good day.
You too.
Bye.